Thank you. I'm here today representing the appellant, Ms. Kyrstyen Davison. Ms. Davison is the mother of Kenyon. The appellee, Mr. Paden, is the father of Kenyon. This case arises out of the juvenile court of Montgomery County, in which the juvenile court judge completely reversed a parenting plan that had been in place since February of 2014. Ms. Davison is here today to ask the court to reverse the trial court's decision. While this court is typically hesitant to second-guess a trial court's determination regarding parenting plans, this court has also stated that it will not hesitate to do so when it finds that the child's best interest would be served by another parenting arrangement. I think it's important to point out a few key facts here. The first being that the child, Kenyon, is now 11 years old and had previously been living with Ms. Davison for primarily her entire life. Ms. Davison lives in Tennessee and Mr. Paden lives in North Carolina, and given the distance between the parties, Mr. Paden would only see Kenyon a few times a year at best. This case began when Mr. Paden filed his petition to modify a parenting plan, and while that matter was pending, Mr. Paden filed a motion for an ex parte restraining order. That ex parte restraining order was granted, and then a hearing was held on the full restraining order. The ex parte petition alleged that the mother had left the child home alone to care for younger siblings. The mother denied these allegations. After a hearing on that motion, the trial judge granted the restraining order and ordered that Ms. Davison could not remove the child from the father. The court did not make a finding that that the child was subject to a likelihood of substantial harm as required by TCA 36-6405B. And then at a final hearing, the trial court ordered that the child would stay with Mr. Paden as primary residential parent, and Ms. Davison would only have holiday visitation.
So what was the material change of circumstances that the court found?
Well, Your Honor, my argument is that the judge didn't really find one. All he stated in his order was, quote, that a material change in circumstances has occurred warranting a modification of the parenting plan entered February 21st, 2024. And I would say the same thing as related to best interest. The court only stated, again, in the same paragraph of the court's order, the court has also considered the factors in TCA 36-6106 and finds that the attached parenting plan is in the best interest of the minor child. That was the only mention of any of the best interest factors, and that was the only mention of material change in circumstances. So that, along with those two errors of not including and going through the factors and finding that there was actually a material change in circumstances and stating what that material change was, another error that I believe the court made is granting that restraining order without finding that the child was subjected to a likelihood of substantial harm.
Is there any remedy, though, for let's assume you're right about the argument in terms of there wasn't a substantial harm. Is there any remedy at this point that the court can grant with regard to that error, or is that error essentially one that we're just kind of stuck with, assuming it is?
Right. There really may not be at this point. The child has been with the father and was with the father during the pendency of the case from that restraining order. But I think it also goes towards why the court ended up making the decision that it ultimately made. The court heard this hearing or had the hearing and heard the allegations of what the father alleged that the mother had done, which was leaving the child at home alone, which again the mother disputed, and that carried over into the final hearing. And the trial court really, based on that, just seemed to have some serious contempt for the mother. Looking through the final order, the court made some very specific statements, basically saying that the mother did not extend the father respect that he deserves, stating that the mother had a village and that the court, quote, wishes that the mother would have utilized that village to help facilitate a visitation exchange, and continuously.
The court found finding 3, mother's testimony not credible.
Yes.
Wasn't there other testimony?
There was.
That she did not leave the child alone?
There was a lot of testimony that the child or the mother did not leave the child alone.
Was that testimony criticized by the judge or found not credible, or?
Not in anything that was stated.
So we don't really know what even what mother said that he finds not credible, do we, from this order?
Right, there was a lot
It
of
just says
testimony.
mother's testimony not credible.
Right.
Okay.
So there was a lot of testimony that the mother made, including at what had happened with those text messages were really where the father got his allegations from. She did give some context to those. She also, testified about her relationship with the child, testified about how her home is, testified about all of these other things. And again, the trial court just made a finding that he didn't find anything she said credible. And I think that points to the contempt that this trial court judge seemed to have for the mother. Spawning from whatever that may be, the court didn't really make it clear on why he disliked the mother so much. We can only assume. But
do we know from the order at all what factors the trial judge used in determining that this was in best interest, the best interest of the child, to change the custodial relationship as substantially as it was changed here?
Again, I would say no, not really from the court's order. What the court said, or did point out certain things about, an issue that there was when the mother failed to meet the father halfway at their typical meeting point. That happened one time in the child's 9 years of life. The trial court did mention that. The trial court mentioned, again, the situation with leaving the child at home. And then other than that, the trial court made no specific findings of fact related to any of the best interest factors, relating to the bond that the child and the mother had, relating to who had been the primary residential parent for a majority of the child's life, relating to, again, any of the 14 factors that the court is supposed to consider. Again, that statute, TCA 366106, is a shall. It states that the trial court shall consider those factors. And that just wasn't done here.
Is it enough for the trial judge to say, I have considered those factors? Is that sufficient? And the trial judge says, I considered the best interest factors. Is that enough for sufficiency of the order?
I would argue no. Again, like it's a shall consider. Most orders that I see practicing family law go through each and every order and state whether or not that factor favors the mother or father, whether or not it's equal, whether or not it's not applicable. That just wasn't done here. And again, I can't really say why. I don't know if it was the trial court, again, just kind of seemed to be over and done with this case, didn't want to deal with it. That may not be reflected in the written record, but that is what was happening at the time.
Is it a fair synopsis of what you're saying, that the trial judge used a lens of punishing the mother for having done wrong rather than making a determination based on the best interest of the child?
I absolutely believe that's what happened, which is not a permissible purpose to modify the parenting plan. It is well settled law that custody and visitation should not be granted or withheld for punitive purposes, but that is exactly what happened here. Again, the trial court really held some obvious contempt for the mother.
What was the circumstance of mother not delivering the child halfway to?
So the reason for that is that happened. I believe it was the summer of. Yes, I believe it was the summer of 2020 during the height of the COVID-19 pandemic, and the mother was a healthcare worker at the time. So for, again, the one and only time in the child's life, the mother said, I can't come to the halfway point. You can still come and pick her up, but I'm going to need you to come here. And
why was that? She couldn't get off work or what? Yes,
it was couldn't get off work, didn't want to be potentially exposing other people, and again, the mother, I believe that was a reasonable accommodation or a reasonable request. The trial court did not believe the same, and again, the trial court went over and over how disrespectful the mother was to the father, and how the father did not how the mother did not co-parent very well with the father, but then did not consider these facts, that the father was not necessarily willing to make this travel, was not willing to co-parent with the mother as well.
And where does that come from? Mother's testimony? What the father did or didn't do to
I believe both parents testified to that. The father, it was one of his main allegations in the petition, that in his original petition to modify, that mother failed to meet halfway. Now, like I said, I do believe the father did end up coming the entire way, but he used that against the mother as an allegation in his petition.
Did father in his testimony indicate that he wasn't using all of his visitation time prior to the change?
He did. So the original parenting plan offered the father a 1 weekend a month visitation, and I believe his testimony was that he had never exercised that monthly visitation, or maybe had 1 or 2 times. That visitation required him to come to Tennessee to exercise that weekend visitation, and again, I believe that the father testified that he had never come to Tennessee. So the only visitation this child for 9 years of her life really had with her father was the summertime visitation, and then was Christmas break visitation, and I think spring and fall, which I do believe the father exercised those. And really what happened here was this child was at the father's, in the father's care at his visitation for summer. The father filed his petition, or filed his motion for a restraining order during the summer while the child was with him. And essentially the child went for summer visitation and never came back. That is not in the best interest of the child. That is not stable. This court has said multiple times in various cases that stability is one of the main things, main factors to be considered in a parenting plan, as well as children thrive in stable environments. And again, the court completely uprooted that child for, in my view, no other reason other than the fact that he just didn't like things that the mother did, didn't like the way that the mother talked to the father, and just for some reason did not like the mother at all, for whatever reason. So the court entered this parenting plan that is not in the best interest of the child. There had been no material change in circumstances, because these two were essentially in the same position that they were at the time. Mother was still living in Tennessee, father was still living in North Carolina. There had not been a change. And as well, there has to be, when you're changing the primary residential parent, it is actually a higher standard. So even if there had been a normal material change in circumstances, there was not a material change in circumstances which affected the best interest of the child, which is the requirement when you're changing the primary residential parent.
All right, we'll hear from you further on rebuttal. Thank you. Mr. Davison, you have the right to come to the podium, and we look forward to hearing, Mr. Paden, forgive me, my apologies. As you may have observed from hearing the case before you, you've got 15 minutes to present your case, and we might have some questions for you, but
yes, sir.
The floor is yours.
All right, so this all began in, I believe, 2022. I had originally filed for a modification of the parenting plan. So when I originally filed for the modification, it was just to try to extend my summertime, and I was seeking medical records and everything because I was denied of ever having any of her medical records from my daughter. So, every time I reach out, Ms. Davison would say, that's not your right, because Ms. Davison was covering my daughter under her grandfather's military benefits. So they never afforded me the right to have these medical records and everything. So I was seeking answers. I went, excuse my voice too, because I'm kind of like, that's why I got my little face mask on, but excuse my voice.
Well, it's up to you if you want to wear the mask or not, but we might be able to hear you better without the mask, but that's completely up to you.
Yes, sir. So, and before then, I was having a lot of issues with communication on things. My daughter would go to the hospital, stuff like that. And, I wasn't afforded any of that information. So I was like, I'm gonna file this motion and seek answers. So in the midst of me having my daughter, I found a phone that they have sent down here with her, they had these text messages in there that she was being left home alone, that she was, you know, that she would ask her mom, Kyron's crying right now, what do I do? And different things. My daughter has a history of seizures. She also has at the time, they was thinking that she had autism, which turns out that after me getting medical testing, it is ADHD now. So, you know, these were some of the things that, you know, I mentioned when it came to the ex parte, that, hey, my daughter has something going on. She suffers from seizures, and, you know, and yes, she may say, oh, well, she hasn't had a major seizure in such and such amount of time, but she still gets tested yearly to make sure that her seizures aren't affecting her or anything. Like literally the other day, and I know we can't really talk about that stuff, but you know, she has, this stuff affects her. And so me being a father, and I'm like, she's home alone, I'm like, let me file this ex parte to try to protect her from being left home alone, being in circumstances where she has to figure out how to change a kid's diaper and everything, and watching her little brothers and stuff. And further down the line, you know, the judge granted the ex parte. So while Kenyon was in my custody, they had like her medical records I was trying to get. Because of this complication with the insurance, I couldn't get anything. I had literally filed a motion for almost criminal contempt just so I can get the medical records, because Ms. Davison had a sign of power of attorney that she afforded her grandfather. And I'm still trying to figure that out, how that was possible. So, and also another thing that happened is my daughter had really bad head lice when she was coming here, and that was another thing that Judge Tim Barnes said, that this was one of the worst head lice cases he ever seen. So it was just a lot of multiple things going on. So we go down there, and then there was another thing that was mentioned too, about her getting signed up for Boys and Girls Club. You know, my daughter doesn't have my last name. She has Ms. Davison's last name. But they signed her and submitted those documents to the court under her husband's last name, Mr. Gaines. So Judge Tim Barnes found that very disrespectful. And amongst everything else that was going on in this case, and also the unwillingness to co-parent.
There's a point at which, it's my understanding, Ms. Davidson moved, it may have been Clarksville to Columbia.
Yes.
And that you didn't receive, you tried to find out where she was, where she had moved to, and she wouldn't tell you? Can you walk us through that a little bit? What?
That's the thing about it. She moved out there, and I found out from my daughter that she moved. And, you know, they're supposed to let us know when she moves out of town, because I'm in North Carolina. So, you know, it's a 10-hour drive from here. I drove from here yesterday morning, in the middle of the morning. So I don't get all this stuff in real time like I would like to, like medical information and stuff. So yes, I was never afforded to be told where she moved. It was like me having to ask these questions to find out what's going on, not knowing what school she goes to and different things like that, you know? So it was just always me playing a cat and mouse game with her to try to find out what's going on with my daughter. And she also,
with the schools, you had difficulty accessing certain information from the
Yes.
schools because your name, Ms. Davidson wasn't listing your name on school forums.
I wasn't getting my name listed, and there was a school actually out there in Clarksville, Tennessee, and I would add my name to the list, and she would actually, and I couldn't get proof of it, but she would actually go in and remove my name. And every time I called the school, I had to add my name back. So it was like almost like she was she didn't want me to be involved in her life, even though I was trying to be involved in her life so much. And, you know, like I said, I didn't originally ask for full custody. I was just going in for a modification. But when I found everything else with it, on top of everything else that was going on, you know, from the head lice to you not affording me any medical records to head lice medical records to, you know, the unwillingness to co-parent. And It was also, give me a second. Yes, so the headlights, unwillingness to co-parent, and just when I got her, like, I'm trying to sign her up for school because at this point we don't know what's going to happen at the final hearing. You're not even affording me the chance to get the medical records to make sure that she was situated for school because she's not responding to my messages. She's not doing any of that. She's just kind of like, you figure it out. And I figured it out. I got her signed up for school. I did everything I needed to do to make sure. Can I grab a piece of paper over here?
Certainly.
You know, which kind of leads us to today. Like, I think that, you know, the whole reason for us being here is to try to find out or try to find an error in what Judge Tim Barnes did. But I'm like, the reason we was even in court was all the errors that were done before then. All the stuff that I wasn't afforded. I proved it. I put text messages up that showed the unwillingness to co-parent. I did all of this. You know, I don't have an attorney now because this was financially draining. And now, you know, I was like, no, there's no way I'm not gonna come up here and represent myself here because I don't want nobody sitting there trying to paint a picture of what it is. And now to the point that I'm still having issues. And that's why I don't know if you guys seen what I put in for my brief, but it's not a typical brief, but Kenny is not getting the financial support she needs now because people have went here to afford a brief or to the point that she's $2,000 behind in her own child support. And, you know, and I was just like, you know, I'm doing everything I can to make sure that, you know, Kenyon is good where she's at. And that's pretty much all I have for you guys, unless you guys have some questions for me.
Any further questions? No, sir. Thank you, Mr. Paden.
Thank you.
Ms. Spada.
Your Honors, I'd first like to point out that Mr. Paden brings some new arguments to the court today that he did not brief in his I guess, brief that he submitted to the court. So I would say that Your Honor should not take any of those new arguments into consideration. When it comes to the issues that he did brief, a lot of those again seem to be issues that may be contempt issues now. These are new issues related to anything that he wants to allege regarding child support, anything that he wants to allege regarding any sort of violations of the parenting plan.
So if we look at the judge's order,
Yes.
and he lists a lot of things, and then he gets down to number 14, and he says, father impressed him with his willingness, I believe that would be to work with mother. I think the word work was left out or something along those lines, and co-parent, and that the court has not seen this willingness from mother. All these things that the court lists, using stepfather's name with the child, not giving him medical information, and the other things that fall all under the rubric of refusal to co-parent. And is that really what the order, the ground is based on, refusal to co-parent?
It could potentially, but again, even if Your Honor does believe
He
that
didn't spell
is
it out, but
right. It doesn't list every single factor, go through everything. But again, when we're looking at a material change in circumstances, we have to look at for changing the primary residential parent, there has to be a change in circumstances that rise to the level of affecting the best interest of the child. Does the fact that the child is not, or the mother may not be communicating about medical records or educational decisions, does that rise to the level of something that affects the best interest of the child. I would argue that it doesn't, because that's not something that the child is involved in. The child doesn't know
Well,
about that.
Potentially, if the child goes for the summer with the father and he doesn't know medical conditions that the child has, that could very well affect the child, couldn't it? If the child gets sick or whatever.
If the child gets sick, I would say it doesn't really matter, because the child or the father could take the child to the doctor.
I think
If it is
always
something
matters. The doctors always want to know what conditions they have.
Right. Well, I think the allegations are is that the child or the father is saying that it was the mother's fault for him not being able to access the medical records. Mother would dispute that and say that those medical records were always available for him to have. He was always listed as the doctor, always listed as a person at the doctor's appointment.
Was the child listed under some other man's last name?
So that did happen with the Boys and Girls Club.
Then
Now, my client.
Would not that impede the father's ability to obtain information?
Again, that wasn't done at the doctor's office. It was done only at the Boys and Girls Club, where she would go to essentially daycare or a program. And the
But it
only reason
begs
that it
the
was
question
done.
of the motivation.
Well, the motivation was the mother worked there at the time, so it's easier just to make sure that these two were tied together. The mother's name, I've been referring to her as Mrs. Davidson. Her married name is now actually Mrs. Gaines. And then that's the child that's the name that the child used at the Boys and Girls Club, and at the Boys and Girls Club only. Not at the doctor's office or anything like that.
All right, thank you both for your arguments. We will take this matter under advisement, and our decision will be in a written opinion, and the clerk of the court will serve that by mail or email. If you give the clerk your address, they'll provide that. All right.